Welcome back to the Law News Network, everybody. This is Jesse Weber. They're taking a lunch break right now in the Adam Matos case out of Pasco County, Florida. Saw some interesting testimony today, not from experts, which we saw from the last few days, but actually from family members and friends and coworkers and people that knew the victims in this case. So I want to talk a little bit about it. Here with me right now is the senior editor of LawNewz.com, Ronn Blitzer. Ron, great to see you.
Great to be here.
A lot to talk about in this case. Let's see. Let's first start with the idea of Tanya Carlson. Now, Tanya testified to the fact that she was Megan Brown's coworker and friend, and I thought it was very interesting, the part of the testimony where they knew the car. Megan left her car at the Fisherman's Shack, okay? And we know that that car, after I think it was the night of August 27th leading into the morning of August 28th, she went out for drinks with Megan, and that car never left that area until one night after 2 a.m. That's when the Fisherman's Shack closed up. It disappeared. And I thought it was interesting when she said she blocked the car in so that no one could take the car during the working hours, because if anybody that wanted to take the car, they'd have to talk to them first, because she knew something was up. What did you make of her testimony?
Yeah, that was definitely interesting to hear her account of how she went out with the two of them, and that the car had remained in place, and then suddenly it wasn't.
Yeah, I thought it was interesting also when she was testifying to the fact that she was out with Megan. They were out, they were having drinks, they were out at a bar, they were with Nicholas Leonard, and Megan started receiving all these text messages, and there's an objection put forward by the defense. The prosecution asked, well, who were these text messages from? The defense objected, and they had a sidebar, and in the end they said, listen, she said, okay, who were these texts from? Adam Matos. How do you know? I saw on the phone that it was from Adam Matos. Okay, from the text that you saw, what did they say? Why is that important for our viewers to know, and also for the jury?
It's important because if she sees it, then she can talk about what she recalled. But if she didn't witness something in particular, then you have hearsay issues, because if Megan had just said, oh, this is what Adam said to me, then that gets a little trickier as far as hearsay. But if it's something that that the witness herself viewed with her own eyes, there's a little more wiggle room.
And let's talk about those texts. Those texts from Adam, she personally saw these texts. They said that Adam sent her, you need to get back home. You're a bad mother. He cursed her out. Obviously, Megan was upset about these. You couple that, remember, this is what all the jury's hearing today. They hear those texts. Then they also knew that Tanya testified to the fact that the first time she ever met Adam Matos, and I think the last time she ever met Adam Matos, he came into the Fisherman's Shack and requested that Megan leave with him before she had the opportunity to speak to her new boss. So the jury's hearing that, and they're hearing a guy who's pretty controlling.
Yes, this definitely explains why the defense would not want all these messages to get out. It paints a very bad picture of the defendant, showing him as being controlling, being very demanding of her time, being very critical, and being hostile in the text messages. So it paints this picture where you could believe what happened next, allegedly.
Interesting, because they had a sidebar with not even a sidebar, hearing with the judge and the attorneys about the fact that in those that conversation, that incident when Adam came into the Fisherman's Shack, the prosecution wasn't going to press Tanya Carlson about the fact of what really happened, and according to what really happened, he used physical force to get Megan out of that restaurant. And the prosecution said, we're not going to go there. Why do you think they didn't want to at least try to get that in, the idea of him being physical and moving her out of the restaurant? I figure if I'm the prosecutor, I would love to get that information in, but they said, we're not going to go there.
Yeah, that was surprising. Whether or not they'd be allowed to get as much detail as they would like out there is one thing, but I would imagine that if I was handling that case, I would want to try to get as much of that out there as possible. So that's a little tricky. I'm not really sure.
Before we move into the general context of this case and different facts of this case, I just thought today, so far from what we've seen, has been really difficult to hear, because you hear the family members, and particularly the last time they ever spoke to these people, and they didn't know this was going to be the last time they speak to him, and you hear the grandfather of Jim Thomas, the grandfather of Megan, the father of Maggie Brown, and then you hear Daniel Leonard the last time he spoke to his son, even this friend, Michael Unsworth, the last time he spoke to his friend. It's really chilling.
Yeah, this is another day of some really difficult testimony to hear. Yesterday, a lot of it was investigators, medical examiners. A lot of that can be very dry, but some of it went into the states of the bodies and the injuries, and that can often be tough as well. Now you're getting a more personal sense of the effect that it had on other people who knew the victims and what their impression was in the moments leading up to this horrible situation. So yeah, it's really difficult to hear these people who knew and were close to these victims.
There was an interesting part when Daniel Leonard was testifying today, and I want to talk to our viewers about it. The defense said, have you ever heard of Michelle Stinson, or do you know of Michelle Stinson? Now, we know that Michelle Stinson had a relationship with the victim here, Nicholas Leonard, and apparently she was stalking him. And I know that Adam Matos, and we believe that his defense was going to point the finger at this woman as maybe the possible perpetrator of this crime, but that was objected to because the prosecution said that is outside the scope of the testimony that was given under direct examination, which is a good objection.
Yes.
But the defense didn't get a chance to really open that Michelle Stinson file, that Michelle Stinson area. I would imagine they're going to keep trying to do that with other witnesses.
Oh yeah, they're going to try as much as they can. If they don't get the opportunity, then when the defense gets the chance to present their case, then they can bring that up. They can do whatever they want. But when you're cross-examining the prosecution's witness, if the prosecutors don't mention that, you can't talk about it. You can only address what's being discussed on direct. Now, if a witness volunteered certain information and opened the door, then you can go there. Otherwise, that stuff is off limits for now.
And it's so interesting because this woman, I think it's the first time the jury might have heard this name. Again, the defense didn't do their opening argument. And when you see in other cases, Ron, like we saw it in the Aaron Hernandez case, right? Alexander Bradley. The defense could keep bringing him up as a possible, that there was something more to that. Maybe he was the one who committed the crime because he was intimately involved in that whole series of events. Michelle Stinson is somebody who's not intimately involved here. She's a third party that's being brought in. So the defense is going to have a really hard time during the prosecution's case bringing up that name. So what was interesting is we know the defense didn't put on an opening statement. They don't even know if they wanted to bring up their own case, but it's looking like the more they can't bring that up in the prosecution's part of the case, they're going to have to put on their own case, right?
Yeah, well, the fact that they tried bringing her up at all tells me that they're going to try to present their own case. And bringing her up now, even if they can't ask questions about it, just the jury hearing that name at least plants the seed. It's a preview of what they're going to try to put forward during their case. So you can't unring a bell.
Yes, but they objected to it. So technically the jury's supposed to not pretend like they didn't hear it.
You and I both know that doesn't matter. And that is a trick that attorneys can use during these cases. You mentioned something. Now, if I was the defense, I wouldn't keep doing it over and over and over again because then the jury's going to look at this negatively. But you mentioned it once now. You maybe mention her maybe one other time with another witness just so that the jury remembers that name. And then the defense, when they're calling witnesses, can talk about her some more. And then if the defense gives their closing argument, and then they could say, oh, remember how the prosecution didn't want you to hear about this when they were questioning witnesses? Well, then you heard more information when we gave our story, and this is why. And then you go that way.
They're going to need to put on some case to point the finger at somebody else.
It's not much, but it looks like that's where they're going.
You think they're going to put him on the stand? Do you think the defense is going to put their client on the stand? We had David DiPietro on saying that he's 100% sure they're going to put him on the stand, specifically because of these facts, where he was living at the house. He didn't give the truthful story about the last time he was at the house. We need an understanding of what happened. It seems like they might put him on the stand. What do you think?
Normally, I would say no. You almost never see a defendant go on the stand in a case like this, but no, I'm inclined to agree with that. They didn't give an opening statement. They're now they're planting seeds for some sort of defense without much. I'm expecting them to put the defendant on the stand in this case, just so they could get some information out there, something that they can look to on closing arguments that they can say this wasn't the person who did this.
What's interesting is we saw the testimony of Michael Unsworth today, Nick's friend, and talking about he asked him, are you going to take your gun with you when you go over to the Browns' house? And he said yes, this Kel-Tec gun that we believe might have been used or in this crime. And Aaron Keller said it yesterday that the defense has a possibility to say that this was a powder keg waiting to blow, that there was so many high tensions between Megan, her parents, Nicholas, and Adam Matos. And perhaps there was an instance where Adam was on the defensive. That's how the defense might flavor it, that he was just defending himself, that they took violence first. And possibly the idea that the jury now hears that Mr. Leonard brought a gun to this situation, the defense can kind of try to play with that a little bit, right?
Yeah, absolutely. You take that situation and the theory that this other person could have been responsible for it. Normally, I don't like having multiple defenses or multiple theories of a case for the defense because it undermines each of them. But in this case, the defense could say, listen, we don't know what actually happened, but it could have been this, it could have been that, but it wasn't this, it wasn't Adam Matos who committed these murders.
No, he just lived in the house after the crime.
Right. Yeah, well, I'm not saying it's going to be easy for them, but if the defense has different things, different seeds of reasonable doubt that they can try to plant, that's, I think, going to be their best bet. It's probably not going to work, but yeah, that's, I think, what they're going to try to do.
What was the defense trying to do here when they said that Tanya Carlson, you knew that there was a problem between Megan Brown and Adam Matos, and you could have called 911. You should have called law enforcement when her car was there. She wasn't responding to coming in, and there was more that you could have done. And the prosecution said, wait a minute, you had more going on in your life. You knew the police were involved because of the 911 call. But you know what, Ron? Hold that question, because we actually do have activity now in the courtroom out of Adam Matos' trial. So let's turn right now